Let's do it.
We're ready. You are. Are you ready with your cameras?
Yeah.
Good.
Okay, hi all. Thank you so much for coming, and apologies for the brief delay. As I said previously, the food's running slightly late, but when it arrives, just we'll set up and come and help yourselves find out. So, second thing is just a reminder that this event is being recorded. As you can see, there's a camera guy in the back. So just please note, and if you're not comfortable being recorded, we welcome you at future events, but for this one, we're having a camera. So, okay, so I'm a little out of breath, but sorry, someone's coming in. All right, I'm going to continue. So, my name is Keaton. I'm the chapter president of the Federalist Society this year. We're really glad you're all here. So, the Federalist Society is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our constitutional order, that it is the duty of the judiciary to say what the law is and not what it should be. With that, I'm really pleased to introduce our speakers. So, Professor S. Stryker, here, our moderator for today, is the Dwight D. Opperman Professor of Public Law here at NYU, where he joined the faculty in 1978. Here at the law school, he directs the Center for Labor and Employment Law and the Institute for Judicial Administration. He teaches courses on appellate advocacy, foreign relations, and labor, employment, and employment discrimination. He served as chief reporter for the American Law Institute's Restatement of Employment Law, published in 2015. In 2016, he was appointed by the UN Secretary General as a member of the UN's Internal Justice Commission. He received his BA from Columbia, his MS in Industrial Relations from Cornell, and his JD from Columbia Law School, where he was the editor-in-chief of the Columbia Law Review. After graduating from law school, he clerked for Judge Harold Leventhal on the DC Circuit and Justice Lewis Powell of the United States Supreme Court. Thank you for coming. Josh Plackman, in the middle, is the Centennial Chair of Constitutional Law at the South Texas College of Law in Houston. He's an adjunct scholar at the Cato Institute and a frequent contributor to the Volokh Law. In addition to his many contributions to our legal discourse, Blackman also founded Fantasy SCOTUS, the internet league devoted to betting on outcomes of Supreme Court opinions.
Not betting. That's not legal.
I'm sorry.
Prediction
not
market,
betting.
please.
Strike that from the record.
We follow the law in this society.
So what does it do?
For fun. Entertainment value.
I see.
Kenneth Marcus is founder and chairman of the Louis Brandeis Center for Human Rights Under Law. He has served as Assistant U.S. Secretary of Education for Civil Rights, Staff Director of the United States Commission on Civil Rights, and was delegated the authority of the Assistant U.S. Secretary of Housing and Urban Development for Fair Housing and Equal Opportunity. Before entering public service, Mr. Marcus was a litigation partner in 2 major law firms. He's a graduate of Williams College and UC Berkeley School of Law. Thank you for coming.
Okay.
Okay. Thank you all for coming. This is a discussion of anti-Semitism in recent litigation, and we have 2 very distinguished speakers on this topic. On the moderator, we're allocating each of our speakers 15 minutes, and there'll be some commentary from me and some discussion among the group, and we will reserve 15 minutes for Q&A. And why don't we start? Who goes first? Ken. You can sit wherever you'd like to be.
I'll stand if that's okay. Thank you for the kind introduction. Good to see all of you. This looks like a great audience. I think I've seen some of you before, but others of you are new. Wonderful to see every one of you. I'm glad that you are here. So I want to say one thing. If you hear only one thing I say, please remember the following. We at the Louis D. Brandeis Center are hiring. If you are a scathingly brilliant NYU law student willing to work for public interest wages, please see me afterwards, or I'll leave some cards with other folks here. A few months ago, I testified before Congress, and a member of Congress pointed out that some members of the opposing party had argued against my position, and he said, do you feel vindicated? He meant by October 7 and the incidents that followed. I had difficulty with the answer because I could say yes in a sense that in some respects what I had projected had come true, but I certainly don't feel it in any victorious sense. It is an awful feeling to see what has happened throughout our country over the course of the last year. I'm going to speak primarily on some of the legal background so that Professor Blackman can speak to some of the cases that have been argued or decided in the past year or so. Let me give you a few background on the issue of Title VI since the full title of this event included the words Title VI, and then I'll also speak to applications for matters relating to Israel and also to freedom of speech. When I discuss Title VI in the context of campus anti-Semitism, I always do it with a caveat. People sometimes ask me, because I've done so much work on Title VI, including developing the doctrine under which anti-Semitism cases are brought, whether I see myself primarily as a Title VI lawyer. And the answer is no, and I hope that none of you will either. I see myself as a lawyer, which is to say, someone who tries to communicate with clients and potential clients, find out what's happening, and what legal responses, if any, are appropriate to it. In other words, I try to avoid addressing a set of facts with a preconceived notion of what statutes will apply. Even assuming that in a particular incident we are talking about anti-Semitism and anti-Semitism that's actionable, there might be an array of different legal authorities, statutory and otherwise, that are applicable, and I try not to prejudge that in advance. Nevertheless, this is the title, so I'm going to say a few words about Title VI. Let me assume to begin with that you know a few things about the background. You are aware of the Equal Protection Clause of the 14th Amendment. You are aware of the 19th century civil rights laws that followed that constitutional provision, and the fact that they were in many respects ineffective even after the Brown versus Board of Education decision in establishing equal protection under our laws for persons based on matters such as race, color, national origin. In 1963, the then Kennedy administration sent Congress legislation relating to issues that had been rejected over and over again within the Congress during a continuing battle. At this point, they were focused, I would say appropriately, on the question of racial segregation in the public schools. And yet, we're also drafting legislation that would address a broader range of issues. Not just different sectors, like the workplace, public accommodations, etc., but also other groups. Most parts of what later became the Civil Rights Act of 1964 included race, color, national origin, and in many cases also, in some cases also, sex. And they included all of those even in contexts in which it's unclear why. Those words are just used over and over again, just as they had been in prior legislation, both federally and in the states. But at some point early in 1964, a decision was made to take out the word religion as it appeared in what would become Title VI, the sixth title of the Civil Rights Act of 1964. That was the statute that prohibited discrimination on the basis then of race, color, or national origin in programs or activities that receive federal financial assistance. For our purposes, that includes, among other things, pretty much every public elementary and secondary school, every public university, and nearly every public college and university, nearly every private college or university, because nearly every private college or university, like this one, receives some amount of federal financial assistance from the United States government and in particular the U.S. Department of Education. So here was the strategy. Make federal funds to colleges, universities, and public schools contingent on following anti-discrimination rules, and then later, through other legislation and appropriations, give enough money so that there were real incentives for schools to be bound in this way. So now we have a statute that says that recipients of this federal financial institution, colleges and universities like this one, for instance, may not discriminate on the basis of race, color, or national origin. What is the difference? We already had an equal protection clause. Why is this meaningful if Brown versus Board of Education hadn't fully been executed and was still being massively resisted? Well, the notion was that Congress was creating an enforcement system for the rights that had been established the prior century. It was a three-part enforcement system. First, private parties would be able to sue in court. That has real advantages if you have the money to do it, or if you have a public interest group like your future employer, the Louis D. Brandeis Center, who can bring the case. Advantages include that you may decide for yourself litigation strategy, perhaps being more novel or creative than federal bureaucrats would be. Disadvantages include that you have to pay for it. There's a second aspect which is the Department of Justice can come in as a amicus in cases that are brought by other parties. Well, that's fine if someone's already brought it. They can also bring their own cases in segregation matters. Now, depending on how you view statutes, that could be a big deal or not a big deal. When you think about campus anti-Semitism, you might not think about segregation. And maybe you're right. I should tell you that most administrations, Department of Justice, have viewed desegregation broadly. That is to say, if there is any segregative impact, it can be considered segregation. There are many colleges and universities where we are told in an awfully routine way that students are transferring out of their college because of anti-Semitism. That could be the basis for an argument that there is a segregative impact. The DOJ has gone forward with less. I mentioned DOJ for the sake of completeness and also because it's a dog that hasn't barked. That is to say, if you can't remember any recent DOJ campus anti-Semitism cases, that's because they haven't brought any, with one possible exception, which is the Cornell case where one undergraduate student was pursued by the U.S. Attorney's Office for threatening to kill Jewish students. With that exception, which was brought under federal criminal statutes, DOJ has been really uninvolved, which means that it really is the last provision, which has been the biggest one. I don't want to downgrade the lawsuits, and it's possible we'll hear about lawsuits, but there are at most a handful of campus anti-Semitism lawsuits in a record-breaking year, whereas in a light year, there might be 10 or 15,000 OCR cases, not just anti-Semitism, on the full range.
Office of Civil Rights.
Office for Civil Rights of the U.S. Department of Education, the agency that has primary authority for enforcing Title VI against colleges and universities. But OCR, which some people think needs to be explained to you, correctly so, most people haven't heard from it, about it, has been taking 20,000 cases this year. 20,000 cases. When I say that they have about 100 or 150 shared ancestry cases, including anti-Semitism cases, that sounds large until you realize what a percentage of 20,000 that is. In other words, it's less than 1%. So what is the basis? How can you say that anti-Semitism violates Title VI now that you know that Title VI prohibits discrimination on the basis of race, color, national origin, but not religion? The floor manager explained that there were reasons of expediency why religion was taken out of the Kennedy bill that had been introduced the prior year, by which he almost certainly meant that there were concerns that both Catholic and Orthodox Jewish constituencies in the Northeast might join Southern and perhaps Midwestern segregations, and in opposing Title VI, if they felt that otherwise they as religious institutions were bound by it in such a way that they would not be able to hire priests or rabbis or teach their religious doctrine. So now we have a statute that doesn't include the word religion. Until almost exactly 20 years ago, OCR quietly took the position that this means that Jews aren't covered, and for that matter, neither are Muslims, Sikhs, or other religious minorities, even if they are a member of a religious group that also has ethnic or ancestral characteristics. 20 years ago, I established a policy for OCR, which has now been followed by 10 cabinet-level agencies, which says that if you face discrimination based on your membership in a group that has both religious and also ethnic or ancestral characteristics, you will enjoy the same level of protection as if you were a member of a group that had shared ethnic or ancestral characteristics but no shared religion. Now, the perhaps obvious common sense, simplistic, equal protection basis for that is or free exercise basis for that is that groups should not be divested of civil rights protection simply because they have a shared religion. There's another basis that I'm going to describe very quickly because it's a little complicated and I know you're very bright. The other basis is that Shari Tefila applies. In the case of Shari Tefila versus Cobb, the Supreme Court considered whether congregants in a Maryland synagogue could sue under a 19th century civil rights statute that prohibits essentially racial discrimination in property when their property was vandalized. Doesn't mention religion. In the lower courts they lost, and they lost again, but at almost the same time, an Arab American professor won on analogous claims before both the trial and Court of Appeals. So both cases arrived at the same time, and the court decided them together and unanimously decided that this 19th century civil rights statute that
This
doesn't
is
mention
42 U.S.C. 1981 and 1982.
that doesn't mention religion, nevertheless applies to Jews. Why? Two reasons. First, because in floor debates, members of Congress indicated that Jews and Muslims would be covered. Second, because contemporaneous reference books, including dictionaries and encyclopedias, also confirm the notion that Jews and Arabs were considered to be members of racially distinct groups. Some people then argued that if this was the rationale, if we looked at the original intention or original public meaning, then Jews would not be covered under Title VI of the Civil Rights Act of 1964 because no member of Congress stood up and said, I think Jews are a member of a distinct race, nor would they, just 2 decades after the Holocaust. And in fact, reference books and anthropology and other scholarly tomes were very explicit in stating that Jews were not a member of a distinct racial group because they wanted to make sure that they were taking a position contrary to the racial pseudoscience that had preceded the Nazi Holocaust. So when I headed OCR, people would say the rationale under which Title VI, the rationale under which the 19th century statute protects Jews would undermine their right in 1964, because in 1964 it's different. Well, I have several different reasons that I developed at that time and gave why that wasn't true, and I've just told you one of them, which is a kind of a common sense equal protection or free exercise argument. The other, and I'll just say it quickly as I can, if you've read the affirmative action cases from Bakke through at least the Grutter and Gratz cases, you'll see that the Supreme Court, when it decides a race discrimination matter under both the 14th Amendment and Title VI, only does one analysis. It only looks at whether there's an equal protection clause argument, and then, after answering that question, applies it to Title VI in the same way. Whatever the answer is under the Equal Protection Clause, it's the same answer under Title VI, which is counterintuitive because their words are very different. Yet what the court says is that since the purpose of Title VI was to create an enforcement scheme for the rights protected during the prior century, the rights established under Title VI should be coextensive with those that had been created before. And therefore, under Shari Tefila versus Cobb, Jews are covered, and for that matter, other groups, including Muslim, certain Christian groups, and Sikhs.
Can I
as
ask
well.
you a question?
Yes.
Aren't litigants better off if they have 1981 because they don't have to depend on the government? They can bring a private lawsuit, and I think you said OCR wasn't all that active anyway. And so there's an argument. They have if 1981 provides the same sort of protection as Title VII with respect to anti-Semitism, then why does it matter?
I didn't intend to say that it wasn't very active. It's got over 100 cases pending,
But,
and the advantage is you don't have to pay for them. In Shari Tefila versus Cobb, the congregants spent many years
That's a good point.
in extremely resource-intensive litigation before they got to the end of their process.
Is there a private right of action under Title VI?
There is, and one can sue under that. But let me say another advantage of the government pursuing these cases, aside from the obvious, which is that it's extraordinarily expensive And so most cases wouldn't be brought if individuals had to pursue them on their own. Right now, as a result of the current batch of Title VI cases, if you are a college administrator, you're reading Inside Higher Ed, you're reading the trade papers, and you are seeing that the Biden administration's Office for Civil Rights is sending a message to university administrators about what they need to do. And they're sending that message in a way that appears to have impact. Now, one could argue that the in-court litigation has other kinds of impacts.
Yes.
You can do discovery and you can get transparency and potentially really tell a story that's not otherwise available. And you could potentially get a lot more money,
Right.
but it's much more expensive, hard to get to, and most people wouldn't be.
So
able
now
to
there
do
are
it.
both avenues. Ken, I wonder if you could wrap it up in 2 minutes, because I want to give it to
Okay.
Josh, and then we'll have a Q&A across the board, and people are about to eat, I guess.
Okay, so I will just do 1 minute on free speech, and I'll skip the IRA part, but I'll answer any IRA
We'll
questions.
talk about IRA
later.
afterwards, I promise. Promise.
One thing I'll say about the First Amendment, that's, unless you were going to cover First Amendment in the context of the current cases with OCR.
I was not planning to.
Okay, so let me say OCR has a number of cases involving speech issues. In my experience, generally when we find a lot of hate speech on a college campus, we find hateful conduct. That is to say, in most instances, even if a client comes to us talking about hateful speech, we can do a little investigation and find that there has been conduct as well. Where cases involving just conduct have been brought to OCR, it has had basically two different choices, and it has said no to both. On the one hand, there are some who say that if the standards of harassment are met, if a hostile environment is present, then free speech doesn't apply, and a college might act as if this were not speech. OCR has rejected that perspective. The other view is that if pure speech is involved, it is protected under the First Amendment, and therefore there is no obligation on the part of a university to respond to it. OCR has rejected that position as well. The position that OCR has taken instead is that both the First Amendment and Title VI need to be followed, which is to say, if the federal standards of a civil rights claim are met by pure speech, there may be an obligation of the institution to respond promptly and effectively, but in a way that doesn't punish the speaker or limit the speech.
Right, Ken, if you don't mind, let's
Okay, I'll turn to Josh.
Josh,
Thank
and
you.
then we'll have a three-way conversation. Well,
And the
Josh, you wanna
pizza.
sit up there, where do you want to be, Josh?
Sit down here.
Okay.
And the pizza is making its rounds. So thank you so much to NYU for holding this event. I know this is not an easy topic to talk about, but it's an important topic to talk about. And thank you all the students here for giving us a respectful audience. I'm grateful for that. I mean that. So Ken, I think, gave a very thorough background of Title VI and how it's been interpreted by the executive branch now for about 2 decades. And I have to give Ken some credit because he was sort of the progenitor of many of these ideas, but they've taken on sort of institutional capacity, and both Republican and Democratic presidents have continued this approach. What I'd like to do is talk about what happened in the wake of October 7th on college campuses. Now, many of you perhaps are 1Ls or 2Ls, but you were alive the last year and you've seen what has been going on at different schools. And I'll focus on 3 schools in particular: UCLA, Harvard, and MIT, and Columbia, a different story. The reason why I focus on those 3 is that there have been decisions by federal courts on these decisions. And what I'll try to do is go through the facts as relayed by the court. And as you all know from CivPro, when you have a motion to dismiss, you take the facts in
Josh, which
favor.
court is this?
Okay, so the
decision?
Massachusetts was from the District of Massachusetts, and UCLA was from the Central District of California, I think.
Okay, thank you.
And as you know from CivPro,
These
when
are
you,
all trial court decisions.
all federal district
Trial
court.
court decisions. now.
Correct. So when you have a motion to dismiss, you take the facts in favor of the non-moving party. So these facts might be contested, but they're at least good enough for present purpose. So let's start with UCLA, which I think was perhaps the most visible of these cases. In April 2024, a group of students occupied a portion of the campus near the Quad, and they built an encampment. Now, this was not merely a place for people to sleep and to protest. They actually built barriers that had plywood and other pieces of metal. And they actually started distributing wristbands. Who was allowed to cross these? Now, what was the criteria? How would one get a wristband? If you supported the existence of the state of Israel, you did not get a wristband. You were excluded from the zone. And in order to walk to different parts of the campus, you needed to pass through this area. The district court found that protesters directly interfered with blocking students' pathways to classrooms. They set up an unauthorized encampment with canopies, wooden shields, and water-filled barriers. And in particular, this made it hard for students to attend their final exams or perhaps study in the library. Okay, those are the facts in UCLA. Harvard, a bit more happened at Harvard. On October 8th of 2023, just about a year ago last week, again, the day after October 7th, about 30 groups issued a statement holding Israel responsible for unfolding violence. This was before any ground invasion. This was the day after October 7th. About 10 days later, student groups organized a die-in involving students in which members of the groups, quote, harassed and physically assaulted Jewish students. Protesters marched through campus, they staged classroom walkouts, and they rallied in areas staying over time. There were frequent chants of From the River to the Sea, Free Palestine, and Globalize the Intifada. Plaintiffs allege, in this case, that these are genocidal calls for the destruction of Israel and its inhabitants. This bullying also spilled into the classrooms. One torts professor announced a topic for a final exam on the Israel-Gaza conflict. Imagine that. The registrar intervened and they changed the exam topic. A Harvard law student assaulted a Jewish student in October 18th, die-in, but he kept his position as a teaching fellow in that Civ Pro class. Okay. On January 2nd, Harvard students posted a flurry of anti-Semitic messages on a university group chat called SideChat. They included students proudly accepting the label of terrorist, calling a Jewish student a pedo lover, it's short for pedophile, claiming all of you Zionists are killers and rapists of children, okay, and referring to Jewish students' nose as crooked. These were all messages in a Harvard group chat. One student, last name Kestenbaum, really nice guy, reported this group. He complained to the administration. What did the administration do? They terminated his access to the group. So he was removed from this chat. Okay, in late January, there were
Point of
posters.
information, was it a university-run chat room? Was it a private?
I'm sorry, I misspoke. Okay, thank you, Professor Stryker. Yes, no, this was he was limited from this side chat. Actually, I'm not entirely positive. It says university-wide group chat. I got to check that one.
Okay.
Fair point. Always keep me honest. All right, in late January, posters memorialized Israeli citizens were taken by hostages, were vandalized with a message saying Israel did 9/11. And these are all things happening on the campus. There was an encampment that began in April of 2024 at Harvard. Harvard did not stop people with backpacks, tents, suitcases, and carts from building the encampment. Eventually, Garber, who was the interim president, reached a deal where they would shut down the encampment if, in exchange for the university expediting administrative hearings and promising leniency to those who engage in the campus. In other words, we will let you get off the hook from any discipline if you close this nice encampment. During one of the protest rallies, demonstrators blocked Jewish students in a study room, and they were, quote, surrounded and intimidated Jewish students. Many Jewish students felt compelled to remove clothing that identified themselves as Jewish. They wore ball caps on top of their kippahs if they were attending Jewish events.
Who is requiring them to remove clothing?
No one's required. They felt compelled. They were afraid.
Students felt
Yeah,
compelled.
they felt
Gotcha.
compelled,
Gotcha.
exactly. Okay. There are some allegations of double treatment, for example. Chabad was ordered to remove a Hanukkah menorah from campus each night, for being vandalized, but there was a wall of resistance that was given 24/7 protection.
When you say was ordered, I mean, that's a passive voice, and I'm not trying to attack you, Josh, but who ordered it?
The opinion says Harvard required.
Harvard ordered it?
I'm happy to check the record sites later. I don't remember this one. This
Okay,
is from the
thank you.
Harvard complaint decision.
That's why you should avoid passive voice, because it's unclear who's saying what.
You're right. You are correct, sir.
Yeah.
Okay.
Strike and white. You're good.
Eventually, Garber created a task force to combat anti-Semitism. He appointed Professor Derek Penzler as one of the co-chairs. This created some scrutiny because he argued, I'm just going to read from the opinion so no one doubts me, that anti-Semitism that does not involve Jewish people being, quote, attacked physically should generally be acceptable. And this professor has claimed that veins of hatred run through Jewish civilization. He's still the co-chair of this task force. He's actually a professor of Jewish history. Okay. Let's go to MIT, which is, in fairness, probably the least bad of the troika. On October 8th, again, a number of groups said that the Israeli regime is responsible for the unfolding violence. Protesters shouted at Jewish students, "Your ancestors didn't die to kill more people," to a Jewish student, alleging that, you survived the Holocaust to do this. That's the allegation. There were chants from the river to the sea, Palestine will be free. They conducted die-ins. But what's sort of different about MIT is that as early as November, the president, her name is Kornbluth, who still holds her job, unlike the president of Columbia and Harvard, threatened students with disciplinary action, including potential suspensions, and they ordered them to vacate. He also suspended a couple student organizations that were involved in this activity. An encampment was erected in April 24, protesting MIT's ties to Israeli academics. It's the boycott, divest, and sanction movement. The president told the students that this violated policy, but at that point did not remove it. But shortly thereafter, she said, if you don't take your tent down by 2:30 p.m. on a certain day, you will face disciplinary actions. All but 5 students complied. They removed the encampment. Another encampment began later, and that triggered litigation. Okay, so I listed them in this order, in my mind, in the level of egregiousness. The Harvard was, UCLA was perhaps the worst, then the Harvard and MIT was probably towards the bottom. Columbia, you all saw what happened last spring. There were faculty and students who were praising the Hamas atrocities on October 7th, calling them awesome, great feats, astounding. People were chanting, burn Tel Aviv to the ground, death to the Zionist state. We don't want 2 states, we want all of it. From the water to the water, Palestine will be Arab. That's one of the slogans they had as well. And Jews out. There's some curses. Fuck the Jews, death to the Jews, fucking Jews, kike, go back to Europe, go back to Poland, you guys are inbred, Zionist pig, and baby killer. You got the entire king caboodle there.
Josh, if I can just cut in, just because, what's the legal theory behind these lawsuits?
I am happy to go there right now.
Okay, only because I'm trying to keep this
Sure.
under a time frame.
Of course. So the argument under Title VI is that these students were denied access to educational facilities. The easiest place where this is manifested is at UCLA, because there's a literal obstruction. This encampment actually blocks students from walking to class. They cannot get to certain facilities unless they have one of these wristbands. And the school took almost no action to stop it. A federal district court in July or early August of this past summer issued a decision finding a violation of Title VI. And the court entered a preliminary injunction. And what was sort of contested there was, at the time, the semester was over, obviously, and the encampment had been dismantled. But there's still, as Professor Epstein will attest, in standing law, even if the current iteration of the law perhaps is not being violated, there are exceptions to mootness, right, Professor Epstein?
We have an
That was
expert witness here.
We were talking over
We have
lunch
an
about
expert
this
witness here.
issue. So the court found that even if the university had dismantled the current encampment, that there's still the risk that this could recur. And that unless any sort of court order was in place, they need to have some sort of let's say preliminary injunction to prevent this wrongdoing.
This was an injunction against the university.
Correct, it was against the university, exactly right. So the court issued a preliminary injunction, it was either in July or August of this past summer. Initially, UCLA filed a notice of appeal. And then about 8 or 9 days later, they said, okay, never mind. And they dropped the appeal, and they issued what's effectively a revised policy. And the policy says, basically, if any individual is obstructing access to a facility, we will promptly, and that's in the policy, restore access to the students, while also limiting the risk of disruption to campus operations. So they understand that it might take some effort to remove this, but they'll move promptly. And if it is not possible to promptly remove the barrier, the university may deem it necessary to deny access to all students. In other words, if there's a certain area where students are being obstructed from and they can't safely clear out the obstruction, they'll just shut it down and clear out the entire facility. This might be what we saw at Columbia come last spring, when they basically just raided the building and brought everyone out. If you can't clean the building out, you have to basically empty it altogether. Okay, that's the legal situation that unfolded in California. The Harvard one also, the court found that yes, was a violation of Title VI. And again, it wasn't as an obvious obstruction because there's no physical blockage. But still, the Harvard court found that this sort of persistent and nonstop degree of confrontational physical violence, where the students feared this would keep occurring, and this harassment affected their students' lives. They, quote, dreaded walking into campus, they would miss class, and they would stop participating in various
Josh,
extracurricular
the theory
activities.
of the lawsuit is that the university is not meeting its obligations?
Correct.
Under which law?
Under Title VI, right? So the theory is the failure of the university to address these repeated acts of anti-Semitism made it functionally difficult, if not impossible, for some Jewish students to attend educational process. So there's no one literally standing in the school's door saying you may not enter. But if the environment is so, if I use the word hostile, or so persistent that you have this, it actually obstructs your ability to be there. The court also found that there were some differences in enforcement where certain groups were allowed to stay in facilities from the pro-Palestinian groups. Meanwhile, other groups that sought to reserve rooms were not allowed to. And that is sort of a prima facie evidence that this rule was not being enforced in an even-handed manner. Now, the opinion from Massachusetts was by Judge Stearns, very smart judge, a Rhodes Scholar, just a smart guy. In the same week that he ruled in favor of the Jewish students at Harvard, he ruled against the Jewish students at MIT. So again, the same judge, you think judges might be biased, he split the difference. He said, okay, Harvard Jewish students, you prevail, MIT Jewish students, you don't.
What
And
was
I
the-
wanted to,
What was the difference?
I'm happy to tell you the difference, Professor. The difference is that the MIT faculty and administration were proactive. They started taking actions at a much earlier juncture to impose discipline on the various protesters. Now, the judge in the MIT case said, look, it ain't perfect, right? But the standard is, were they acting reasonably? And so the MIT administration was not, I just quote this, I want to make sure I'm just reading this right. It was not clearly unreasonable. That's the phrase used, right? It was not clearly unreasonable what the MIT administration did because they took actions. He said, look, you don't have to be clairvoyant. It's very difficult to predict from day to day. If you do this, then this will happen. If you do this, this will happen. You can't be charged with clairvoyance. But what MIT did was better. Now, I'll wrap up in a moment, so he's getting my time. The Columbia case is still pending. There was a motion to dismiss that was filed, I think, in June in SDNY, just right down the block. It was Kasowitz Benson put in a 235-page complaint with allegations up to the wazoo. Just lots
Kasowitz
of
is the firm for,
the Jewish students in Columbia.
okay.
And they put in a complaint, 235 pages. So I won't even try and summarize it, but there's a lot in there. That will probably be decided at some point this
Who's
year.
the judge?
I don't remember.
Okay. So we have 3 district courts.
Yes.
All
Yes.
ruling that there was a violation of the university's duty under Title VI. Is that
Okay, so
correct?
the MIT one, MIT prevailed. So
MIT prevailed.
UCLA lost, Harvard lost, MIT
What was
prevailed.
the ground of the decision in the MIT case?
Again, the judge in the MIT case
Can you hear me,
distinguished.
folks?
Yeah.
Okay, good.
Yeah, the judge in the MIT case distinguished the Harvard case, which was decided about a week apart, in that the MIT case, the administration took much more proactive steps to remedy the situation and was just not willing to sort of sit back passively. I think the allegation was just a little bit less egregious. It was not clearly unreasonable. That's
So
what the
the-
MIT judge said.
Uh-huh.
So it's
No violation, basically.
he-
Basically the rationale.
he said, you know, this is not great. This is not something you want to put in your alumni magazine, right? But this is not rising to the level of federal law violation with Title VI. That was the gravamen of the MIT case. That's all I got.
Okay, thank you. Can I ask Ken a question? We have a short period of time, and I want to have some Q&A at 2 o'clock. I think we're over at 2:15. Ken, the International Holocaust Remembrance definition, tell us a little bit about that.
The so-called IRA working definition
Yes,
of
yes.
anti-Semitism
Yes.
provides a definition of what is anti-Semitism that includes a number of examples relative to Israel. It is the examples that have generally had weight, that have made a difference in cases. And those examples, generally speaking, and as the Clinton State Department, I think, pointed out very well, fall under 3 categories. Natan Sharansky's 3D test categories, which is to say, generally speaking, they involve incidents in which Israel is not merely criticized, but is evaluated under different standards, or demonized in a way that the Jewish people had been demonized, or delegitimized in a way that the Jewish religion had been delegitimized. In other words, it draws parallels to the way in which the Jewish people collectively had been addressed over the years.
These are examples in the definition.
In the definition,
Uh-huh.
which has now been embraced by 35 states in
Right.
to a different degree,
Right.
in either gubernatorial decrees or state legislation. It's also embodied in an executive order, which is now integrated into the policy of OCR,
Right.
which you now know has authority over colleges and
There's a
universities
letter of
like this
July
one.
7, 2024, right, from OCR? Is that what you're referring to?
I was referring to,
Okay.
in 2020, it was integrated into.
This is
the
a May
SAT
7, I'm just
order.
saying, it seems that OCR is adopting some of the examples,
All.
all of them.
They've all been
Okay.
adopted by
So-
the executive
let me-
order, which in turn is
Let me
adopted
raise
by
the more
OCR.
general question. I am a strong supporter of Israel. My parents are buried there. My parents were victims of the Holocaust. But there is a difference between anti-Semitism and criticism of Israel. So help us figure out where the line should be drawn.
The IRA working definition explicitly says that criticism of Israel is not necessarily anti-Semitic. However, it provides certain criteria for determining what is and what is not. And broadly speaking, they fall under the 3D test that I've described.
What are the 3D tests again?
Um,
I'm sorry to do this to you.
Is Israel not just being criticized but evaluated under different standards in the same way the Jewish people had been? Is it being demonized, that is to say, ascribed almost demonic characteristics? Is it being delegitimized, denied a sense of legitimacy?
Let me ask you a question. Why do we have to get into this if Jewish students are being denied access to facilities and they can't get into the libraries and that sort of thing? I just don't. I understand that the Title VI mandate is limited to religion and national origin, by the way, which I think is a theory you might want to pursue as well. But I just don't understand why we have to get into Israel. Israel's being diminished. I mean, help me understand that. In other words, I am a student, Jewish student. I want to go to I'm in a classroom and Israel is being demonized. Now, that is a misuse of the professor's role. There's no question about it. The professor should be punished for that. But why is it discrimination on the basis of religion or national origin?
What the professor is saying?
No, that the university not.
It-
Okay.
it-
Let's
it-
take the
it-
professor
it-
first. Take the
it-
professor
it-
first.
It may not be.
Mhm.
So first of all, we do use national origin
Good.
discrimination,
Good.
and that is the primary basis
Mhm.
of all these OCR
Okay, good.
cases as
And-
well.
Good.
Second, the executive order and therefore OCR policy indicates that these examples may be used in order to determine whether conduct is motivated by anti-Semitic intent. So for example, if someone is blocked from going to class and it's unclear why they're being blocked, this can be used to determine. So for instance, if someone is blocking someone else from going to class,
Right.
and saying something about Zionists, this could be used to determine whether this student was being blocked for merely political reasons or for reasons that would implicate civil rights laws.
So Zionism is a code word for being Jewish? Is that the theory?
Well, there are multiple theories.
Okay.
Code word is one of them, and that's, I believe, an approach that this university has followed. Another is that since Zionism is integral to the identity of so many Jewish Americans, it might be tantamount to denying Jews because it is an ethnic trait of the Jewish people. So those are two separate theories.
Zionism is an ethnic trait.
Yes.
Okay. All right. There again. Help me out with that. Why is it an ethnic trait? Can you hear me? I can't hear myself. Why is Zionism an ethnic trait? I'm not coming here as anti-Zionist, by the way. I just want to understand the notion.
So the notion is ethnic or ancestral, to use the language of Shari Tefillah versus Cobb. And the notion is that when you are excluding people who view themselves as connected to the state of Israel, that is tantamount to denying Jews. So let's suppose you were denying people who said, I support the Pope. There may be non-Catholics who are supportive of the Pope. There may be Catholics who don't support the Pope. But if you're saying we don't want people who support the Pope, it will generally be understood that what you're trying to do is screening out Catholics.
Now, you're targeting Catholics there.
Yes.
And you're saying the same thing is going on here.
Correct.
It's the code. It's a code, basically, is the concept. Am I getting it wrong now? That seems to be the principal theory, that it is it's a way of referring to a person's Jewish background.
You know,
See, I'm a
people-
little worried about saying-
people use
Yeah,
words a little bit
that's true,
differently.
that's true.
So if by code you are implying the notion of intent, I'm not sure that that's necessary to all of the theories.
Right, one other question, and I'll put it up to the floor. What should the universities be doing here? This is for John.
Sure.
What are they failing to do?
Sure. I think, and the fact that this audience is being so receptive and just, not disrupt them, I'm actually thankful for that. I think universities have sort of gotten the memo. They are worried about Title VI liability, which can be quite draconian if fees or any sort of supervision is imposed. I think they should, frankly, take hostile conduct towards Jewish students the same way they would take hostile conduct towards all other students. We have institutions at every law school. You can call it whatever you want, whatever initials you want, DEI or anything else. These institutions exist. In the wake of October 7th, many of these institutions were quite quiet. And in fact, some were actually less than quiet and said things that were actually quite harmful. They actually expressed solidarity with some of the people on October 7th who murdered and raped Jewish people. It happened. I think if the existing institutions simply treat under Title VI the shared ancestry that can develop as the same way they would treat someone based on their race or religion, race or gender, I think they can do it. It's difficult to imagine, and just to sort of swap the races. Imagine people were running down the hallways of Columbia chanting, slurs about, African American students or Hispanic students. I think there would have been a lot more outrage, and I think the schools have taken far more decisive action. So look, my recommendation, Professor Stryker, enforce your policies evenly, and I think we're in a good spot, and I can't blame anyone. Just you have policies in the book, just enforce them.
What about the statements that professors make?
Right, and this is the First Amendment issue that I think Ken and Professor Stryker were talking about. Of course, NYU is a private institution, so the First Amendment free speech does not apply here, but I think all universities aspire to have free speech protections. And look, I'm very sensitive to punishing a professor who gives a lecture or some sort of speech, extramural speech, as is called, on Israel. I think there have actually been probably some disciplinary actions against professors that probably were out of bounds, and I think we need to be sort of careful. I also think when you're hiring and you're considering whether to grant tenure, you have to have some notion of academic freedom. So I, in some perverse way, I would probably be supportive of professors who've been punished for this extramural speech. I think, though...
It's not necessarily extramural, it's in class.
Right, so...
It's in class,
I-
and
if
they're
it's-
taking advantage of a captive audience, for sure.
Right, and again, maybe I'm a bit of a squish here. I do think professors, even in the classroom, should have some latitude, because I frankly
Right.
worry that someone will try and shut me down.
Right.
But their classroom lectures should be within the ambit of a class. If you're talking about a 1L torts exam, and your hypothetical is about murdering Jews, committing atrocities, okay, maybe that's not a good example. But if this is a class on geopolitics or Middle East policy, then you can talk about it. Now, I think professors have an obligation to try and be neutral and at least balanced in all regards. If you look at some of these allegations of Columbia professors saying things, and I can go through the complaint, they are not being neutral in their classrooms, and Jewish students may credibly fear this. I mean, I could use a name, Amy Wax. She's a professor at UPenn who's in the process of getting canceled. And she made statements that some African American students found very harmful. She made statements about where black kids graduate in the class and so on. And they said, we don't want to take her class anymore. So if you have Jewish students say, I don't want to register for this class, well, if it happens to Amy, then if that's the rule, we should apply our rules evenly.
Even application of the rules. All right, a question from this side and then a question from that side. Sir, second row. Identify yourself, please.
My name's Teddy. I'm a student here. My question is for Professor Blackman. I just want to press you on that last point you made, because as I understand your account of the Title VI suits, is that the universities, the administrators didn't do enough to kind of put a stop to like in the Harvard, MIT especially cases, they didn't do enough to put a stop to kind of decentralize religiously targeted
Mhm.
bullying. But like, do you really want to invite university administrators to be more proactive than they already are?
It's a good
Like,
question.
We have accounts of political radicalism in universities that identifies this fear of liability under an expansive reading of the civil rights laws kind of as the origin point. And so I guess like if you're, say, a beleaguered political minority, you might worry that, asking administrators to be more interventionist could backfire.
The
So-
danger of a more active university role.
Yeah, no, it's a fair point. I mean, and look, I don't necessarily trust these various DEI institutions. I think that, many of these people are good-natured, and I think they have their hearts in the right place, but this sort of the oppressed ideology, which is sort of at the heart of DEI, means you take a side in the Israel debate. That's not the side I like. But I like to think that universities who have a bottom line are fearful of losing funding and seeing fines. Even if they don't like it, they should at least do something. Perhaps one of the biggest travesties of the Columbia situation is that there's been almost no discipline imposed. Virtually all the charges were dropped against people who committed actual property crimes. It's not just like speech. They broke into a building and occupied it. That's a crime. That's called trespass. That's property 101. And almost no disciplinary action. So I think universities should impose discipline. And look, students, especially in law schools, have to sit for a bar exam. Character and fitness matter. So if they actually enforce this in a even light fashion, I think it would go a long way to preventing a reprise what happened last fall.
And an even-handed fashion.
Yeah.
Thank you.
In the back, on the right? My right? Yes. Your name, please?
Hi, I'm Kieran. I'm Jewish and I helped build the NYU encampment, and it was one of the most wonderful and affirming experiences of my life. Anti-Zionism is very central to my Jewish identity. So I was wondering, how do you reckon with the fact that you are discounting the experience of Jews whose anti-Zionism is central to their Jewish identity and have been welcomed in pro-Palestine spaces and collaborated in their creation?
Sure. Thank you for sharing that. To me, it's analogous to Jewish Americans who do not observe certain religious obligations, as I don't myself. For instance, Jews who might have no problem working on the Sabbath. If a particular employer takes action that prevents Sabbath-observing Jews from working, people like myself are not going to be harmed by it, but that doesn't mean that Sabbath-observing Jews don't have the same right to religious accommodation. So I acknowledge that there are times when a hostile environment might be created for Jews in general that will likely not harm every Jew in the same way. And that doesn't mean that it shouldn't be actionable, in the same way that a failure to provide religious accommodation should be actionable, even if it doesn't apply to me.
So I guess the thrust of the question was, is anti-Zionism central to some people's identity, and how should that be treated the same as the Zionist identity that some Jews have, or many Jews have?
Is the question, I want to make sure I understand your question, that by the university shutting down the encampment, which is, you say, essential to your identity, that they are in fact violating your Title VI rights? Is that the thrust of the question?
Sorry, I'm chewing.
That's
It's
okay.
okay. Well,
Take your time.
we don't have to put it on the spot.
Yeah, I mean, I think like for some Jewish people, it seems Zionism is essential to their identity. For some Jewish people, anti-Zionism
Right.
is central to their identity.
Right. Okay. No, I think I got the question. So it's sort of a rub where I make this point a lot. There's no one Judaism. I mean that sincerely. There are what's the expression? Three rabbis, four opinions. Right? There are different opinions on all facets of Judaism, and I wouldn't even purport to say that this is the Judaism. A lot of the complaints have been brought by Jewish students who have a view of Israel, and there have been complaints brought by students who are Palestinian, who think that the universities are infringing upon their own religious and national beliefs. And I suspect, I haven't researched this, that there are probably some Jewish students who have said that the destruction of the encampments and these other disciplinary actions violate their religious freedom. There was a footnote in, I think it was the UCLA or the Harvard case, I don't remember, where they said, we are not here considering whether other complaints brought by pro-Palestinian or perhaps Jewish groups supporting Palestine, how those shake out. So look, I guess it's possible for a group to allege that by destroying the encampments, they're infringing on or they're infringing on some of the rights
John,
of the.
shouldn't it be a
student-
general rule that you know, it's an even-handed rule, you don't have encampments on the campus?
I think,
mean, for
yeah.
a university to
Yeah.
get into these
Yeah.
ideological issues
Yeah.
would be problematic, it seems to me.
Yeah, I think as a general rule, obstruction of property, I'm a property professor, is a pretty easy rule to enforce neutrally. The harder one, you can imagine, one student yells, Jews are murderers, and the other person says, well, Palestinians are murderers, right? And then you have basically people making analogous claims on both sides that could then perhaps be some basis. If the university fails to police either side, that could itself be problematic. I think that might be the thrust of the question as well. But I appreciate it. Thank you for the question.
On this side now, in the rear. Your name?
Hi, I'm Ben. I'm a Jewish law student committed to combating anti-Semitism, and like Kieran, I'm very sensitive to the conflation of Zionism and Judaism because as an anti-Zionist committed to Jewish practice, I know that anti-Zionism and anti-Semitism are very different. And I know this because I've never been excluded from an anti-Zionist space or felt any hostility in an anti-Zionist space because of my Judaism. I also have practicing Jewish friends at Harvard who were involved in the Harvard encampment and similarly didn't feel any hostility there. Yet, my friends and loved ones, many observant Jews, have been harassed compared to Nazis and cast out of Jewish spaces for opposing ethnic cleansing and apartheid in Israel and the occupied territories. And this all happened since, but also years before October 7th. So I find that that policies like the IRA definition of anti-Semitism and the positions being taken in the lawsuits that are being discussed, that conflate the two to be wrong-headed and incorrect. I see it no different as anti-abortion people not being welcomed into pro-abortion political advocacy. And so I guess I'm wondering for how you would respond to Jewish students like me who see the IRA definition and the positions in these lawsuits not as a way to protect Jews, but rather as a way to leverage fear of anti-Semitism to undermine groups that are advocating for Palestinian freedom and inequality.
Can we have just another question here? The point has been made. And I also made the point about what's in the IHRA.
I think it's
This should not be a, anyway, another question.
So I have two. My first is just about a distinction. So do you think there's a distinction between Jews who anti-Zionism is integral to their identity and Jews whose Zionism is integral to their identity, considering that the Jewish religion has references to Israel throughout the religion, but no references to anti-Zionism? So for example, on Passover, we say next year in Jerusalem. When we pray and say the Amidah, we say let's rebuild Jerusalem. When we have in Tehillim, Inashkachech Yerushalayim, if I forget Jerusalem.
So the references to
Yeah, so they're
Israel
referenced. Do you
in
think
Jewish,
that's a meaningful
in Jewish
distinction?
liturgy.
Yeah. Let me answer that one. I want to try and address the gentleman in the back. I want to make sure everyone's question gets answered. Again, I deal with this a lot. You're right. You've described the liturgy correctly, but there are a lot of Jewish people who don't always take all the aspects of liturgy literally, shall we say. People say, well, the prohibition on Shabbos, maybe is one way to read it, but we read it a different way. Maybe the prohibition on kosher is one way to read it a different way. Even the discussion of Israel, I think Jews have different understandings of the state of Israel. So it's a situation where I mean this sincerely, no one group can claim to have monopoly on what Judaism means. I think that's been the history of thousands of years. But I will also say to the question in the back, there's a lot of history here of anti-Semitism, both in the 20th century, in the Middle Ages, and where there's a close connection between opposing the Jewish state and opposing Israel. This is not something Jews have been kicked out of Israel many times over the millennia. And I think when you have the IRA definition, otherwise, you have to sort of view that deep, big, long-standing history in any understanding of history. And to be sure, I think it's a fair question. Why is anti-Zionism different? Manish and I, why is this different from all other types of racism? History, it is. This is not a new struggle that's sort of just abandoned overnight in 1948. This has been going on for a very long time. And I think as a society and as a government, we can take cognizance of that when we're defining, we talk 1619 and racism. This goes way before 1619. This is well before JC. We're going way back.
So help me out. Why does the IHRA, I'm sorry, Valerie,
Sorry, just, is that a meaningful difference, like legally, that liturgy and tradition?
It would probably be an establishment clause violation for it to be a difference. In other words, to say that this is the one definition of Judaism would probably violate, and I think Lemon's terrible law, but I think the establishment clause probably prohibits saying that this is the true Judaism. I think the government probably couldn't do that, even if I agree with you as a matter of faith.
I'm told this ends at 2:10. Let me give the speakers another 2 minutes. Okay. Let me give the speakers another 2 minutes. Okay.
Free Palestine!
Thank you all for coming.
Thank you.
Free Palestine! Free Palestine! Up with liberation! Up with liberation! Down with occupation! Down with occupation! Up with liberation!
Thank you for coming.
Thank you for coming.
With liberation!
Thank you, guys.
You're still on camera, my friend.
Thank you.
Yeah.
Guys, have some more food.